the opponents of this may object for lack of a quorum. I'm going to go tell the clerk that we may not call the roll. Yep, that's where we are.
Is good language? Yes.
That's what I encourage you to do.
The Judiciary Committee will come to order. The Judiciary Committee will come to order.
Okay. 7, 8, 9, 10 I have.
We are going to wait just a minute for a working quorum, and then we will continue considering amendments.
Let me see if anyone's
Okay. A working quorum is present. We will go to the next amendment, which would have been the gentlewoman from California's. She has asked us to skip over that one and go to Mr. Ice's amendment number 7 and 72. And if the gentleman is ready, we will recognize the gentleman from California to offer his amendment.
I thank the chairman. I call up ISA 72.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3261, offered by Mr. Issa of California and Ms. O'Loughlin of California.
Without objection, the amendment will be considered as read, and the gentleman from California is recognized to explain his amendment.
Thank you, Mr. Chairman. I would now ask unanimous consent that a copy of the letter from truly the founder of IPv4 and one of the founders of the Internet sent on December 14th to the chairman by Vince Cerf be placed in the record at this
Without
time.
objection, that will be made a part of the record.
I thank the chairman. As his letter indicates, and as I'll indicate, my provision, which would eliminate, if you will, one of the most onerous and ineffective parts of the bill, would in fact say that a search engine would not be forced to effectively block the link or deny that the link exists or to derail a link to a accused offending site. And there are many reasons for it. I'll be brief. One of them is that it's very clear that you can have hundreds of thousands of these links in a matter of hours. They can come and they can go. So this would not be something that would be part of a deliberative process. It would not be something that somebody at Justice would look at and say, here's a storefront where they're laundering money. This, in fact, could be as simple as a search of documents that might contain the hyperlink to an infringing site. Now, very often, as we all know, and this will continue happening under the First Amendment even after our legislation, if the LA Times runs an article in their online version paper and they're talking about a site that promotes piracy or promotes other things but happens to also include piracy, we would have to look and say, well, Google's going to have to cut off the link to the LA Times page because that link has a link. The nature of the legislation is such that once you say you're going to cut off links, in other words, once you become very China-esque, what you end up doing is you end up starting a snowball effect from which there is no elimination and there's no end. My amendment is very simple. It's intended to say this is not follow the money. It does not follow the principles that have worked in the past, and it is, in fact, part of the entire DNS blocking scheme that is not going to work. I spent more than 20 years, I guess by the time I ended, 30 years in the security business, looking at how to confound people who stole cars. The one thing I know about thieves, and pirates are thieves, is that they will begin working the very next day around what you have. On top of that, when we've considered major legislation in Congress, such as V-chip, something that I worked with when I was in the private sector, we ordinarily said, well, you know, we're going to empower people to turn something off. We're going to empower them to make a decision. That's fine. There would be nothing wrong if this legislation simply said, if you will, that software had to allow people to not know about sites, or that once recognized that there would be tagging. Those are not in the bill. This is a bill about denial in this particular case. Mr. Chairman, if we eliminate and strike that provision, this becomes a bill that is a fraction as controversial. It's a major change. Yes, some will say they need this, but Mr. Chairman, do we really need something that can be circumvented quickly, that the foremost authorities in the industry are weighing in one after another to tell us is ineffective but will hurt the Internet even while not stopping the pirates? So I thank the gentlelady from California, Ms. Lofgren, for yielding, because her next two amendments will probably not be offered if, in fact, this simple, straightforward amendment can be understood and accepted, and we can look then at the rest of the bill in a much more positive way. Without that, I suspect strongly that everyone who is against the bill today will be against the bill to their dying day. And with this change, you begin to make changes in how we view how the rest of the bill could be fixed. And with that, I thank the the Chairman for allowing us this opportunity and yield back.
Thank you, Mr. Eisen. I'll recognize myself in opposition to the amendment. This amendment eliminates DNS and search engine blocking, but it is essential that these provisions be maintained in the bill. DNS filtering provides an effective solution to combat foreign rogue sites that are already among the most popular websites on the Internet. For example, sites that are well known and established as the Pirate Bay. These sites are so notorious that they do not need to rely on search engines to direct users to their pages. Tomorrow's notorious rogue sites could also become popular and gain huge followings through blogs, social media, and word of mouth, not relying on search engines. Without a requirement that U.S.-based service providers participate in blocking access to these sites, these overseas criminal enterprises will continue to thrive as they steal U.S. intellectual property, sell it back to U.S. consumers, and endanger U.S. consumers with phony and dangerous pharmaceuticals and other goods. Search engines are the vehicle through which offshore websites reach American consumers, driving large amounts of traffic. To exclude them would deny the fact that they drive a tremendous amount of traffic to foreign rogue websites. We need to maintain these two provisions in the bill, and for these reasons I must oppose the amendment. Yield back the balance of my time. Are there other members who wish to be heard on the amendment?
Mr. Chairman?
The gentlewoman from California, Ms. Lofgren.
First, let me thank you for taking Mr. Ice's amendment out of order because, as he has referenced, should this amendment be adopted, my amendments 6 and 8 would not be necessary. I don't have Vince Cerf's letter, and I'd love to see it. I know it's been put in the record. But I do have the letter from Dr. Len Napolitano, who is the director of the cyber unit at Sandia National Labs, who points out that these provisions not only would impair cybersecurity, they also won't work. I think that Mr. Issa is correct, that if we were, I prefer the alternative bill that Mr. Issa has taken the lead to craft. I think that's a much better approach. But if we were to clean up the barring of search engines, the criminalization of hypertext links, and the DNS scheme that is doomed to failure and also will make the web actually more prone to piracy, we would actually have a capacity to potentially come together. I'm probably not going to be a fan even with that, but I think there'd be the potential to move together on this measure. And that's why I think Mr. Isa's amendment is so important to consider. I hope that it will be adopted, and with that, I would yield any additional time to Mr. Apollos, who is our Internet expert.
Thank you, and I'll move to strike the last word as well. But I don't know if the Baker letter has been sent to the record yet. This is from yesterday, the December 14th letter. I'd like to submit the letter from Stuart Baker dated yesterday to the record. Without objection?
Without objection, sir.
Thank you. And this letter goes into, again, the manager's amendment, because we were dealing, of course, with a different bill that had previous commentary. And, again, I do wish we would delay this a little bit because everybody's reacting in real time to a bill they just saw 3 days ago. So Stuart Baker raised several positions. Again, I do believe that the ISA amendment will largely address his concerns with regard to security, where he says, quote, unfortunately, the new version would still do great damage to Internet security, mainly by putting obstacles in the way of DNS-EC, a protocol designed to limit certain kinds of Internet crime. Again, the sections that are deleted under this would allow search engines to maintain their integrity. Their integrity is currently compromised under the language on page 17B. In effect, one would have a different search engine if they used it in our country versus Canada versus England, et cetera. Again, on the Internet, these things can have workarounds. You can certainly, if people know that a a web search is superior in another country, they can simply use that version of it as well. They can also use anonymizers in a different area of the bill. But this area of the bill is the most problematic. Again, the conditions that are put upon service providers are that to take down for Americans the foreign infringing sites that are subject to the order would essentially is the operative element that would divide the Internet into a different Internet, balkanizing the Internet, creating a separate Internet that American users would experience from the Internet that other users would experience. It is simply the wrong solution to a very real problem. I strongly support Mr. Issa's Open Act. Again, I believe that this particular bill is a lot less damaging to value creation and to job growth if we can eliminate this provision. This is the most onerous provision in the bill, and I hope that we can eliminate it in its entirety, and I yield back.
Okay. Does the gentleman...
I would thank the gentleman for yielding back, and I would just note that having seen now this letter from Vince Cerf, who is the father of the Internet, he points out that the search engine remedy suffers from the fact that it will not be effective in preventing users' access to illegal offshore websites. And for those of us, and I think this probably includes all of us, who utilize the Internet, it's child's play. It's child's play to actually use a different search that is beyond the reach. I mean, this is not going to work. It will help fragment the Internet. And I would note that the MPAA submitted a list to the IP enforcement coordinator of notorious infringing foreign websites that it had identified. We took a look at each one of those websites, and every single one of them would be vulnerable to a follow-the-money approach because they either display ads or accept user payments. If we were to utilize that method, we would cut them off at their knees. But using this method, it won't work. It will do major collateral damage to the Internet, and it's unnecessary. So with that, I would yield back.
Gentleman's time has expired. The gentleman from Utah, Mr. Chaffetz.
Thank you, Mr. Chairman. I stand in support of this amendment. I worry that we're doing things that will have a lot of unintended consequences, and I'm sure getting the government involved will solve all of our problems. So I'd like to yield my time to the gentleman from California who offered the amendment, Mr. Issa.
I thank the gentleman. Mr. Chairman, Mr. Paulus is probably better at educating people as to the nuances of domain resolution and so on, but let me just give you some food for thought of why, as it's currently drawn, it won't work, and if not redrawn through a markup at a time when we can get to it, you'll have a bill that will be not worthy of being considered on the floor. If you want to block hyperlinks, remember, a hyperlink is just a set of words. The fact is that anyone can type in the hyperlink if you block it, and you can't stop the printed word. We have no constitutional basis to stop the printed word. More importantly, I can go to Zone Edit or any number of other companies, and I can move in a matter of seconds where something resolves to. So when you start looking and saying, well, okay, so there's two legs of what you're trying to stop not working. The third one, of course, which I think Ms. Lofgren did a good job of explaining, is if you simply assume that instead of using Google, where we have tremendous cooperation, we have assistance and a whole team that tries to help in anti-piracy, or Yahoo or Bing or whoever, you simply go to, you know, I guess to be politically correct, we'd say macaca.com search engine, and over there, it's in some foreign country. We can't block it because it's just a search engine. It's not in here. You guys finally remembered macaca. Okay. You go to that search engine, which is just a search engine, but it's outside our reach. It's in a country that would scream bloody murder if we tried to block it, and it searches all kinds of other things, but of course it also doesn't respect this law. Guess what? We've just moved the most popular site in the world, Google, and it's number 2s and 3s and 4s, all of whom are American. We've just moved it offshore in favor of a site that will become popular with Americans and the rest of the world. The world searches on Google. The world searches on Bing and Yahoo. The world does not search on, you know, macaca.com. And it won't if we continue to leave the Internet reasonably free to do this. Lastly, again, I mentioned that you know, we dealt with the V-chip when I was in business. Well, can you imagine the Motion Picture Association, who so much wants this piece of legislation as it's currently drafted, if we had done the same thing to their movies, which were PG, X, R-rated, and the like, and simply said you've got to ban them, they've got to be stopped from being on the cable internet, there'd be a hue and cry. And yet this form of censorship is every bit as bad, because it's not going to be based on one event, based on deliberation of a jury or a judge. It's going to be a default against some foreign entity, and then hundreds of thousands of cease and desist sub-orders issued under it. The fact is there are unintended consequences. I think people who know this industry far better than I do keep pointing them out, and these letters keep coming in. The 100,000 petitions not to go forward with this says a great deal, because it's the tip of the iceberg. Mr. Chairman, I will once again respectfully ask, from a person who I've worked with on bill after bill after bill, treat this more like patent reform, and we will get a better bill. Patent reform, although it took longer than anyone wanted, had a hearing or two or three, and Mr. Sensenbrenner is sitting here, so he knows very well, at subcommittee and full committee, every single Congress, even though we had already worked on similar legislation. We've always on this committee tended to err on the side of more information, more hearings. We're a hard-working committee. This is one in which one company was summoned to be told that they were a problem on a panel where they were the only, if you will, other side. We need to have more than that, and I know that the time is limited at the full committee, but I will tell you, at the subcommittee, I am sure we can get a very, very good section of witnesses so we can do this work.
The gentleman yield.
The time belongs to the gentleman from Utah.
Reclaiming my time, I have just but a few seconds. Let me say again, Mr. Chairman, there are those of us that do truly want to solve this problem. There is a problem. I want to solve it. I just happen to think that this is the wrong way to do it. We have not exhausted the discussion and public discourse on something that is so imperative, such as the Internet. If we cede our nation's innovative abilities on the Internet because we are overly abusive and too quick on the draw to try to draw some conclusions and do some things that the nerds of the world think will actually harm the Internet, then I think we are creating problems for our economic future. I think it'll hurt jobs and the economy. I think we will see things go overseas. I just think we ought to be taking our time. There is no magical date that says this has to happen by, by the end of the month or something like that. I don't think we've exhausted those possible remedies. I yield back.
The gentleman's time has expired. Thank you, Mr. Chaffetz. Thank you, Mr. Issa. The gentleman from North Carolina, Mr. Watt, is recognized.
Thank you, Mr. Chairman. Mr. Chairman, as one who acknowledged in his opening statement that he was not a nerd and doesn't understand a lot of the technological stuff, I'm not the person to argue about the technology part of this. But I do want to address two of these arguments which have been advanced. First of all, that we should follow the money. We are following the money. The bill does that. But that has never been the only way that we go after criminal activity. It's not the only way. Second, I want to address the argument that it won't work. Well, last time I checked, you can put as many locks on a door as you want to. Somebody knows how to use a hairpin to pick them. Somebody knows how to get a locksmith to get in. That is not an argument.
Will the gentleman yield?
Let me finish. I'm happy to yield. That has never been an argument. We will never stop all the criminality here. We will never have a solution that will be completely effective, but we have never had a solution in any area of criminal law, as far as I can tell, that is completely effective. Somebody will find a way. I agree with Mr. Issa. They will find a way to go around the system. They will do whatever is necessary. And for that reason, I'm hoping that we'll continue to monitor this, regardless of whether this bill passes or not. Yeah, I mean, you know, 15 years ago, when these same issues were being raised about the DMCA, nobody anticipated we'd be back here today doing this, but it did not effectively address the problem. This won't effectively address the problem in terms of eradicating the problem, but that is not an excuse not to do something. And this is something for the people it will be effective against. It will be effective. There will always be people against whom it will not be effective. I'll yield to Mr. Cafridge.
Thank you. I think I agree, actually, part of your concept here on point number 2. What I'm trying to say, what I'm trying to convey is you have some real technical experts out there who say, using the analogy of the lock, you're not having a lock and then there's another way to pick it. You're taking off the lock. That's part of the problem. When you talk about DNSSEC,
let me reclaim my time. I started out, you know, I'm not one of these people who's trying to argue about whether I'm a nerd or not. I am not a nerd. Hey, I may look like one. I may act like one sometimes, but you know, hey, I'm not trying to operate my congressional office without paper. You know, I personally don't think that's a good idea, but for those of you who have the capability of doing that, you're welcome to do it. But what I do know is that if you don't put some prudential regulation around the Internet and you allow folks to do on the Internet what they can't do at a pawn shop or in my neighborhood, you know, they'll just go to the Internet, which is exactly what you're saying. They're going around the system now, right?
Will the
so
gentleman?
I'm not arguing with you about the technology here.
But I'm worried about cyber. Will the gentleman yield for just a few seconds?
I'm happy to yield.
We have a number of papers from some very qualified people who say that this hurts cybersecurity.
Well, I don't believe.
And other than saying, well, we got to do something, I agree with you.
I do not believe that. But
with all due respect, how to just say, well, I don't believe that? These guys are experts. I'm looking for somebody to come before this body and testify in a hearing and say this is why they're wrong. Because to date we haven't had anybody.
Let me reclaim my time and ask for unanimous for one additional minute.
Out of objection, the gentleman will be recognized for an additional minute.
First, on the issue of security, the manager's amendment crafts a proposal which accepts the potential that may exist out here and makes that part of what a judge considers in fashioning a remedy. This bill and this amendment are not insensitive to that issue. Secondly, I'd feel much better about passionate concerns regarding the unanticipated consequences of all this if the people who were making those arguments had been coming forth saying there is a terrible problem here with the theft of intellectual property and with the counterfeit goods being sold digitally with foreign rogue websites. Let's find an effective, meaningful way to deal with this. And I tell you, that hasn't happened.
Will the gentleman yield?
That has not.
Will gentleman yield?
This has been going on for several years, and it's not my time.
Well, my time has expired, and
I ask unanimous consent the gentleman be given an additional minute.
With that objection, the
I'll
gentleman
yield to
is
Mr.
recognized for an additional minute.
I appreciate what the gentleman from California, Mr. Berman, has said, but nobody saw this bill but the drafters until it was introduced.
Well, now, I will
Nobody
reclaim
saw
my
the
time.
manager's amendment until it was introduced. So we
will-
didn't have a chance to analyze it.
And no one knew there
reclaim
was a
my
problem
time
with
on
intellectual
that.
property theft until just a couple of moments ago?
Well, come on
I
now.
will
I've been
reclaim my time
yelling
back.
about
The
intellectual
gentleman-
property
I
theft as
will-
long as
Gentleman
you-
from North Carolina has the time.
on that because we've been working on this bill for a long time.
Will the gentleman yield?
This process did not start when the manager's amendment was dropped. So for anybody to come in here and say that they haven't had an opportunity to give input into this process, I just think that's wrong. Now,
Well, with the gentleman yield, you're making a pretty serious allegation. Will you please?
The gentleman from
yield?
North Carolina has the time.
I'm not going to get involved in the technology and whether it's effective or, all that stuff. You all have to debate that. But it seems to me that plenty of time has been given for a discussion of this issue. And if people didn't take advantage of it until 3 days ago when the manager's amendment was dropped, I think that's unfortunate.
Gentleman's time has
Chairman.
expired.
Mr.
The
Chairman.
gentleman from Wisconsin is recognized.
Mr. Chairman, I move to strike the last.
The gentleman is recognized for 5 minutes.
Mr. Chairman, I'll put my credentials on complaining about intellectual property theft against anybody in this committee or maybe anybody in this room. I've been to China with the speaker talking to the president of China. I've been to Taiwan. I've made the point, from the time that we had the debate over whether the WTO accession of China would stop intellectual property theft. I've talked to the trade representative on bilateral trade negotiations. I consider myself a hawk on IPR and theft. On the other hand, my staff kept on asking for a copy of the original bill, and we never got one until it was dropped. And we never got the manager's amendment until it was dropped to be able to look at it 3 days ago. Now, I have definitely a different outlook on how to approach this problem. And I don't think the approach to this problem is exclusively what is in this bill. From the experience that I've had in dealing with Indians trying to sell untaxed cigarettes around the country and other people using other types of means of transportation. Now, granted, those were transportation organizations of things that were not electronic in nature but were goods. But, the fact of the matter remains is that there are some similarities on this. And I don't think the authors of the bill really wanted to reach out to those of us who are saying, hey, there might be another approach that is a better way to do it. And that's the complaint that I have. So, for somebody like the gentleman from California, to call me a Johnny-come-lately on intellectual property piracy, I don't like that because my record is pretty clear, and I was pretty strong on that during my 6 years as chairman. Let's quit the name-calling. Let's get down to the fact that this bill might not be the best drafted bill. It might not be the most effective way of solving this problem, and it might require some improvements so that we can get to the issue of stamping out intellectual property piracy. And I yield back.
Will the gentleman yield? Will the gentleman yield, please?
The
gentleman has yielded back his
I
time.
take my time back. Yield to the gentleman from Utah.
The gentleman from Utah is recognized for the balance of the time. 2 minutes.
Thank you. Look, I think the accusations that I just heard about my sincerity.
What accusations did you hear about your seniority?
Well, I don't have any seniority. That's part of my
Point of
problem.
order,
That's part
it's
of my
my
problem.
time,
Yeah.
and the gentleman from Utah has.
I hope you all notice where I sit on this dais here. Look, I am very sincere. The accusation is I'm not sincere in wanting to solve the problem. There is a problem. I have said repeatedly, there is a problem. I've also said repeatedly, we got some experts that are way above everybody's pay grade in here that have said clearly there might be a problem with cybersecurity in doing this. So I totally agree that there is a problem. I'm worried that the solution is not necessarily the right solution. That is merely, please don't attack the integrity or intentions of what we're doing, because I just got here. I didn't create this mess, but I am here to help clean it up, and I will continue to work on this issue.
Mr. Chairman.
I have to yield back to
The gentleman
Mr.
from
Sensenbrenner.
Wisconsin has the
I
time.
yield the balance of my time to the gentlewoman from California, Ms. Laughlin.
Thank you, Mr. Sensenbrenner. You know, we all have different roles to play, and Stuart Baker had a very specific role, which has to do with cybersecurity, both at the NSA and with Homeland Security. He didn't have a IP role, or he just had a cybersecurity job. And here's what he said in his letter today. He said that what should a browser do if a website says it doesn't have a signed credential? The site might be telling the truth, or it might be a fake site backed by a DNS server that's been tampered with. To find out, the browser needs to ask a second DNS server. Now, if that server doesn't give an answer, a third and fourth, until it gets an answer. That's the only way. Unfortunately, he goes on to say, the things a browser does to bypass a criminal site will also defeat SOPA's scheme for blocking pirate sites. And he goes on to say, faced with silence from the server, the browser will go into fraud prevention mode, casting about to find another DNS server that can give it the address. Eventually, it will find a server, he says, say in Canada, free from the AG's jurisdiction. The server will provide a signed address for piracy.com, and the browser will take its user to that authenticated site. But if the browser...
The gentlewoman's time has expired.
I would ask unanimous consent to just read the next two sentences.
Without objection.
What the browser should do if it's dealing with a hijacked DNS server, if the browser can't tell the Attorney General from a hijacker, and Mr. Baker says it will not, we're going to end up promoting piracy, which is the exact opposite of what the intention here is in the bill. And that's why this amendment should be approved. And frankly, we should have hearings on this whole complex subject that no one, with the exception of Mr. Paulus, is probably an expert on in this case.
Gentlewoman's time has expired. The gentleman from California, Mr. Berman, is recognized.
Thank you, Mr. Chairman. I believe sincerely, but quite mistakenly, several members of this committee thought my comments were directed to them. I would be the last person, having been on this subcommittee, on the subcommittee on intellectual property since I got here, to suggest that Mr. Sensenbrenner or Mr. Issa or any members of this committee didn't care about the theft of intellectual property. My reference was to people not sitting up here, but maybe a few people sitting out there, and some other people who are very directly involved, including some of the people who spent some money taking out full-page ads, and some of the companies that the gentleman from Colorado read in opposition to say, for 3 years, I've been trying to have a real discussion with some of them about things that we could be doing and they could be doing to affirmatively help us deal with the problem of digital theft. And very little has happened. There's been very little response. So let me...
Will the gentleman yield for a quick question?
I will, and I'll be done in just a moment, but I'll yield them. So that was my point. Everybody comes in now with a lot of arguments about, and maybe some good ones on this particular bill, but a lot of the folks who are raising those issues outside have not been interested at all, and to some extent, I have to say, and I understand it, are profiting by the current situation, and our effort to establish a non-legislative dialogue about what could be done about this have come essentially to no avail, because the digital millennium copyright isn't clearly in and of itself is not the answer. Something more has to be done. And then with respect to notice, I got to say, let's not talk about the date the manager's amendment was filed. How long ago did we have a hearing about what ICE was doing about domain names? How long ago did the Senate introduce a bill? I believe it wasn't at the beginning of this year. I think they had a bill in the last Congress on this subject, and of course a bill this year. This is not all of a sudden we woke up on Monday and or when this bill was introduced 5 weeks ago and hear about this stuff. This has been discussed, written about, talked about for years. So let's put all this notion of the last minute and all that into a context that's real.
With the gentleman yield.
And I yield.
Thank you. I appreciate the clarification about the sincerity about the members that serve on both sides of this aisle. And given your concern and need to determine a remedy, is it unreasonable, and would you stand with us in putting a hold on this bill so that we can have such a hearing? That's all I'm asking for at this point is let's have a hearing, bring in the nerds, and get some real answers to what questions this body can't answer. Is that unreasonable?
By the way, are they questions about what's wrong with this bill, or are they questions about what can our U.S. companies and, if need be, the Congress do about effectively dealing with this problem? Because I've been trying for years to get them engaged in this, and they haven't. And so that's the context in which I must most regrettably reject.
Will the gentleman yield?
Would the gentleman yield?
Will the gentleman yield?
The gentleman from California has the time.
Yes. My guess is you got most of their attention. And so
I didn't. That was the problem.
I think they have their attention
Chairman of the
now.
committee did.
I think they have their attention now. Would you concur that it would be prudent to have a hearing dealing with the cybersecurity issues and the ramifications of this manager's amendment? Isn't that a reasonable stance?
I think the reasonable thing is to show the seriousness of our intent by moving this bill forward. That's the reason.
Would the gentleman yield? Mr. Berman, would the gentleman yield?
Yes.
I generally agree with you on a great many things, but, when redemption is found, or at least alleged, you usually look to follow it up. But in this case, it's even more than that. If there's any chance that the bill is not good, if you believe, some of us nerds, that the bill is in its current form is not good, why wouldn't you want to know? Because even if people will never be with you, and maybe these search engines will never be with you, wouldn't it be right to do this research to find out so that at least we do no harm that could hurt our economy in dramatic ways?
And my view is, because of that problem, the chairman put together a manager's amendment which massively changed this and addressed the issues that you're talking about now. Not to your satisfaction, but
not to the public. Not to the public having access to a forum in which we could hear it before our committee, which is much more the tradition.
Mr. Chairman. Mr. Chairman.
The gentleman.
I yield back.
The gentleman from California yields back. Anyone on this side wish to be recognized? The gentleman from Virginia, Mr. Goodlatte.
Thank you, Mr. Chairman. A number of points I want to make about this in opposition to this amendment, which doesn't come with an alternative. And I think the point I want to make is that all year long, I and others who've been working on this have said to those who've come to say, oh, we don't like this DNS blocking, DNS filtering. I've said, well, what alternative can you give us? And it's always follow the money. Well, follow the money imposes a burden on the financial services industry. Following the advertising places a burden on the advertising industry, but no one has been willing to come forward and say, here is a way that those involved can help. Now, having said that, the National Cable Television Association has provided a letter in support of this bill. Why would the ISPs, who rely on the safety and security of the Internet, support a bill that jeopardizes their ability to save their customers? And we have letters from some of their customers as well. So, in terms of the nerds the gentleman from Utah has referred to, I don't know that they want to be characterized this way, but here's a piece that's 6 months old in response to this same debate that's been going on all year, because the Senate has the same issue in their legislation called DNS filtering is essential. DNS filtering is essential to the Internet. The charge that DNS filtering would devalue and fragment the official DNS system of the Internet is inconsistent with reality. Two of the main pirate DNS alternatives that have sprung up to combat government seizure of pirate and counterfeit websites opted not to replace the official DNS system because that would have been very costly for the pirates and problematic for their users.
Could the gentleman identify
I will not yield. I will not yield. I've got a lot of stuff I want to cover and not much time. There is no evidence of DNS fragmentation, he says. That is a professional a network engineer who built and designed wired network, wireless network, internet, storage, security, and server infrastructure for various Fortune 100 companies. He's also certified information systems security professional. He was technical director and editor at large at zdnet.com and wrote one of their most popular blogs, Real World IT. Then we have another piece. Mr. Chairman, I'll ask that these be put in the record. From the Information Technology and Innovation Foundation by Daniel Castro, PIPA and SOPA, Responding to Critics and Finding a Path Forward. He rebuts the charge that DNS filtering impedes DNSSEC deployment. That's
Without objection.
He rebuts the charge that DNS filtering is too broad of a tool. He rebuts the charge that DNS filtering poses security risks to users. He rebuts the charge that DNS filtering will fragment the global DNS namespace. He rebuts the charge that DNS filtering leads or will lead to alternative DNS systems. Then, and probably most interesting of all, we have a blog, the Innovation Policy blog. I asked this be made a part of the record as well. DNS filtering is an American innovation, and it's designed to address the letter that the gentleman from Utah raised earlier, in particular signed by one of the DNS experts, Paul Vixie, who complains bitterly about what's proposed in this legislation. But Mr. Bennett goes on to say, it's interesting to contrast the view in this new blog post with a post Mr. Vixie published last February announcing the addition of a domain blacklisting feature to the Internet's most popular DNS server software, Bind, B-I-N-D, a product maintained by his firm, Internet Systems Consortium. The post titled, Taking Back the DNS, highlights the fact that most new domains are malicious and describes a feature newly added to Bind, that's his term, most new domain names are malicious, that enables ISPs to make such domains effectively disappear from the Internet. His rationale was very straightforward. This is Mr. Vixie saying this. Society's bottom feeders have always found ways to use public infrastructure to their own advantage. And the Internet has done what it always does, which is to accelerate such misuse and enable it to scale in ways no one could have imagined just a few years ago, like when we wrote the DMCA a dozen years ago. Just as organized crime has always required access to the world's money supply and banking system, so it is that organized e-crime now requires access to the Internet's resource allocation systems. They are using our own tools against us while we're all competing to see which one of us can make our tools most useful. This is Mr. Bennett speaking now, this all seems quite sensible. So Congress has followed Vixie's lead in including domain blacklisting in Protect IP and in SOPA. Despite the objections raised by the DNS experts to these bills, domain blacklisting remains a supported feature in Bind. That's Mr. Vixie's product, and was recently upgraded from version 1 to version 2. The feature's formal name is Response Policy Zones, or RPZ. One likely effect of the passage of PIPA and SOPA.
The gentleman is recognized for an additional minute.
Thank you. Would be for vendors of competing DNS systems to adopt the RPZ feature and make it a de facto standard. We will rely upon the Internet nerds to solve this problem and make it work the way it needs to work going forward. We don't have the technical ability in this committee to do that. We never will. We never will. But because we want to be absolutely sure, we put the provision in that Mr. Berman referred to earlier, no impact on security or integrity. Nothing in Title I shall be construed to authorize a court to require compliance with an obligation under Section 102C in a manner that would impair the security or integrity of the domain name system or of the system or network operated by or on behalf of the party subject to the obligation. Now, having said all of that, this is not a new issue. This is not novel to the Congress. It's not novel to our government, and it's not novel to the technical engineers on the Internet, because we use it right now for child pornography. We use it right now to stop malware from infecting people's computers. We use it right now to stop spam from reaching people on the Internet. And we use it right now to combat spyware on the Internet. It is not inappropriate to use it in this circumstance, and we have put protections and measures, and we've listened to the technical engineers, and I continue to talk to and continue to listen to the technical engineers about making changes to this. But I'll also say this, that if they have a better idea, I'm looking for the amendment in this stack of 70 amendments that has the better idea that can do something different, but I haven't seen it. And so my assumption is they don't want to give us a better idea.
Gentlemen.
They want to kill the bill. I urge you to oppose this amendment.
Thank you, Mr. Goodlatte. The gentleman from Illinois, Mr. Quigley.
Thank you, Mr. Chairman. I do cringe a little bit in that, to the entire world, a side point here, we're referring to people that we are talking about being so important, the technical experts, as nerds. So at least we should give some thought to respecting those people that we are claiming to be so important. I want to stress a couple points. First, Mr. Berman was absolutely correct in stating not a majority, but certainly a significant number of those people who are contacting our offices have a vision of the Internet that is unacceptable. It is the Wild West. It is this utopia of freedoms that encroach upon other people's property rights, for one thing. And they care little for that. I mean, they like the idea that at one point in time it was very, very easy, it's still illegal and impossible, to download music without paying the people who wrote it or created it or composed it or anything at all. They just didn't care, and they still don't. So I think we need to appreciate that those who want this bill to stop, because their version of the Internet is a world without any boundaries or borders or decency or respect for people's
Will the gentleman yield? Will the gentleman yield? Brief.
Not questioning your sincerity.
Thank you. I would just encourage and hope that you and other members, the gentleman from California and others, would look at the bill that I introduced with Senator Ron Wyden, which had to do with personal privacy on the Internet and talked about geolocation and privacy. So we need to be careful on how we do this.
I appreciate that, but I just think we need to understand where everybody's at on this. And finally, there are those that think that we should hold off and perhaps not continue the markup. I will tell you, I've only been here a short period of time like you have, sir, and that the fact of the matter is people get serious about an issue when there's a markup. If there's an occasional hearing about something, we dutifully sit and listen to them and ask questions, and then it goes away for another day to be considered. The brilliant folks out there who are advising us on both sides, and that's particularly helpful, are doing so at a fevered pitch because there is a markup. If this was another hearing, it would be a much more laid-back occasion. What I'm suggesting here is the only reason this thing's ever going to move forward is if the chairman schedules a markup. Now, we may not finish today, and if there's 70 more amendments, I'm sure we won't. But it's moving the issue forward. We've agreed now with everybody's sincere, and that we want to move forward. The only difference is I'm suggesting if you don't have a markup scheduled, nothing happens in this.
Will the gentleman yield?
Certainly.
I would concur that it gets everybody's attention to have a markup, but I would also suggest that the comments from the gentleman from Virginia were also very sincere and kind of helped drive home my point. There is controversy about this from the technical side of it, and and correct me if I'm wrong, but my short time here, we have not had a hearing specific to the technical aspects of this bill, and that's my point. Yield back.
Mr. Quigley, would you yield?
Would the gentleman yield?
I'll go in order, so I'll yield to the gentlelady behind me.
I would just, and I thank the gentleman for yielding. Our colleague from Virginia, the chairman of the subcommittee, has identified, I think, 3 individuals who I think are funded by the movie industry to object. We got a letter today from 83 Internet engineers, the people who designed the Internet, warning us that this is a catastrophe. We have a letter from Sandia Labs, that isn't a party to this. They don't have a policy fight in this. They're neutral, saying that this is a catastrophe. We have a letter today from Stuart Baker, he isn't a partisan on the issue of Internet piracy. He's a guy who knows about the Internet. He was general counsel of the NSA for years in the Bush administration, who cautions us not to do this because of the Internet architecture. To say that 3 people who were funded by an interested party is the equivalent of the entire Internet world in terms of engineers and scientists is preposterous. Yes, there's a controversy, but the controversy is why we would listen to people who've been paid to say something that is wrong in the face of the entire Internet science world saying this is a catastrophe. That is the controversy and the mystery, and I thank the gentleman for
Would the gentleman yield?
Mr. Issa.
I thank the gentleman. You know, Mr. Quigley, you and I serve just next door, and I know that you haven't been the proponent of saying it, but if I ever moved a bill in which I had such a limited kind of hearing, a structural bill that required people to do something, it would be incredible at next door. Wouldn't you agree that I've never moved a major piece of legislation without substantive, hearings on?
Well,
what
so
is
you're implying that something. I may be misreading you, but you sort of be implying something about the chairman of this committee.
Well, for example, postal reform. Postal reform. We've had.
The gentleman's time has expired.
Mr. Chairman,
Mr. Chairman.
Just in time.
Mr. Chairman.
Is there someone else
Mr.
who
Chairman.
seeks recognition over here? The gentleman from California, Mr. Lundgren.
Mr. Chairman, my good friend who sits directly to my left just articulated a point of view from several people, which I think proves my point. There is controversy of a technical nature. And Mr. Quigley may think that hearings don't have much of impact on members. I would care to differ with him. I came to the last and only hearing that we had on this with the expectation I would have some answers as a result of having technical people here. I've always found in hearings that it's best to have people of differing points of view who are experts in the same area so that we can, in fact, test them one against the other, much as we do in a courtroom with cross-examination. Now, that may be limited because that's my experience, but I've found that it's one way to get to the facts. One of the problems I find in this debate is we can't even agree on the facts. And if you can't agree on the facts, it makes it difficult to implement your policy. I know this. As the chairman of the Cybersecurity Subcommittee on the Homeland Security Committee, my inquiries into those who are considered to be experts in the area of cybersecurity is that the approach we take in this bill is at least troublesome. I'm not sure I would use the language the gentlelady from California has used as catastrophic, but it's somewhere between catastrophic and troublesome. If that happens to be the case, I do not know why we cannot have the time to consider this, to have those experts. And this with all due respect, this red herring of you don't have the amendment that gives us the answer when I am telling you I'm not sure we know what all the questions are is nothing more than a red herring. We're being asked to pass fundamentally important and changing legislation with respect to the operation of important parts of the Internet without the information base I think that we need. And I would agree with my friend, the gentleman from Virginia, that we won't become the technological whizzes by having experts here, but it will give us a better base upon which to make a judgment. In a courtroom, when you have a jury, you don't have all experts in the jury box. You have jurors who are supposed to apply their common sense based on the evidence presented to them, and one of the best things to do with an expert is an expert who can convert their knowledge into language that other people can understand so they can make a considered judgment. That's all I'm asking for us to be able to do here. And I know we have 2 or 3 people saying that the DNS blocking is not going to affect our ability in protecting cybersecurity, the operation of the Internet. But we've got a whole slew of people on the other side. And I just know from my perch in the cybersecurity arena, they are warning me that we ought not to take this step. Now, maybe we ought to go forward and then listen to them later on, or maybe it makes more sense to try and bring them into the argument
and make the decision. At least it seems to me that's the best way for us to do it. And so I don't question anybody's motivation here or anybody's commitment to protecting intellectual property. What I question is our judgment here. And our judgment is to be questioned if we are rushing to something when it appears that there are remaining huge issues of controversy, not with respect to the policy, but with respect to the underlying facts. And if you want to get a bad jury verdict, all you have to do is make sure that there is no understanding of the facts. And frankly, I think the debate here has shown that we do not understand the facts underlying the decisions that we are making.
Mr. Chairman, Mr. Chairman, Mr. Chairman,
Gentlemen, yield.
I'll be happy to yield.
The gentleman from California still has the time.
Mr. Chairman, I think the gentleman from California has made a good point. There are 60 amendments on the roster. There are probably a dozen or so more that are not on the roster. We're not going to get done with this today. We're not going to get done with this tomorrow. And we're not going to get done with this, before we adjourn for Christmas. How is your side of the argument prejudiced if we have this hearing and then resume the markup, and we'll be able to have more of the facts and perhaps less of the debate, more of an agreement? Now yield back, gentleman from California.
And maybe we can get a unanimous consent that no one will ask that the bill be read again, so that we can take.
Would the gentleman yield?
I'd be happy to yield, my friend from California.
I, for one, certainly would feel that.
Time has expired without objection. The
Mr. Chairman,
recognized for an additional 30 seconds.
I'll be happy to yield to the gentleman.
I thank the gentleman. I, for one, second that we would be more harmonious and more typical of the way we've been if we're allowed to bring in experts for and experts against, whether they're one panel of both together or two. It would fit within the history of how we've done these things. And I think when we look at the background, we've had that. Also, Mr. Chairman, I would ask unanimous consent at this time that the letter from netcoalition.com and the red line of this bill be placed in the record. This was sent to the chairman on December 6th. Obviously, they were not prepared to see the manager's amendment, but I believe that their red line, which was asked for and they responded to, certainly would make for a good base of information for all members to have.
Without objection, the gentleman's time has expired. The gentleman from New York, Mr. Nadler, is recognized.
thank you. This has been a most interesting discussion, which I plan to continue listening to, and specifically the gentleman from North Carolina, to whom I now yield.
I thank the gentleman for yielding. And I just want to make a couple of points. First of all, I want to go back to what my friend Ms. Lofgren comment she made and discourage any of us from talking about who's been bought off or even experts. There's been a lot of money floating around in a lot of different places on this issue. And I just don't think it's worthy of us to be talking about who got bought off and who got hired by whom, especially when we start identifying the people.
Will the gentleman yield for a moment?
Let me just finish.
Sure.
Would the gentleman yield? Because I don't think I used the word bought off.
Well,
I would like to take exception to that.
But and this is not a negative comment about what you say. I'm just trying to get us to be who we ought to be always in this committee and stop questioning. I mean, because if we start that, we could go way off into the deep. It's just not a good practice. For a second, I'm reminded of Yogi Berra's comment, this deja vu all over again for me in this way. For all of the last term of Congress, I sat in the Financial Services Committee. And a lot of these arguments that I'm hearing today are the same arguments that I heard about derivatives. Well, I didn't know a damn thing about derivatives. I'm still not sure I do. But what I did know was that, and the experts on one side were telling us that derivatives were the salvation for the economy, and the experts on the other side were telling us that derivatives and CDOs and all this stuff that apparently appeared to have driven the economy into the abyss were the worst things that could possibly happen. I don't think we're going to be able to resolve this with a bunch of experts coming in, because with fairness to everybody, the people involved in this issue have enough money, otherwise influence, to get experts on both sides of this issue to come in here and tell us. I think we have addressed in the manager's amendment, set up a framework that allows a judge, that allows the Attorney General, that allows the people who ought to be making these technical decisions, whether we are invading the Internet or exposing our security, to make the decisions about this. I agree with Mr. Lundgren. I practiced law for a long time. The people who make these decisions are not experts. We are not experts, but we have set up a careful framework where nothing can happen without a judicial intervention. And we can have as many experts as we want come in here. I guarantee you, if we had 15 more hearings, as we did in financial services on derivatives and all these complex financial things, and still, after we passed the bill, without a single hearing, people cut off the money to enforce what we did, right? They didn't have no hearings about it. Right? Hey, be honest now. Hey, I'm being real here.
All right. Would the gentleman yield?
Well, it's not my time, but I'll be happy to have Mr. Nadler yield to you if you're going to admit to what I'm saying.
I'll admit there was no hearing. I'll admit there was no hearing before that vote. But could I ask this?
All right. Let me give you another example.
Would there be an objection?
I mean, we had hearing after hearing after hearing.
All right. Well, you needed one more.
Mr. Chairman, when Mr. Sensenbrenner was chairman, I asked unanimous consent for the gentleman to have one more minute asking to yield.
The gentleman is recognized without objection for
and I'll yield.
And the gentleman from New York has the time.
When Mr. Sensenbrenner was chairman, we had mega hearings about
bankruptcy.
No. The Patriot Act, right? So we draw the bill and we go to the Rules Committee, and they rewrite the bill without a single hearing.
I can only hope.
Right? Okay. Well, hey, you know, I'm a hearings guy. You know, I think we need to make informed decisions, but I think you all are overblowing the importance of a hearing here. And I don't think we're going to get through with the markup. I mean, as a practical matter, this is going into next year anyway, but I don't think it ought to be going into next year for hearings. We ought to be proceeding with the markup and trying to get through with this. That's the same thing I said to Ms. Lofgren before the bill was dropped. I said, I don't think anybody's really going to get serious about this until we do have a bill.
The gentleman's time has expired. I believe that the gentlewoman from California, Ms. Waters, has a short...
I move to strike the last word.
Gentlewoman is recognized for 5 minutes.
Mr. Chairman, I'd like to have a colloquy with you for the length of time that I have.
I have to, yes.
Mr. Chairman, are you committed to moving forward with this bill today?
Yes, I am.
Are you committed to the proposition that you have spent a generous amount of time on putting together a manager's amendment that has addressed many of the concerns that were identified?
Absolutely convinced.
Mr. Chairman, I think there are some members on this committee who don't know that you're convinced, and they think that they can hold up moving forward with this markup today if they keep talking. Would you please let them know that you're going to go forward with this bill today so they can stop trying to influence you so that they won't.
The gentlewoman will yield. Yes, I have every intention of going forward today, tomorrow, and however long it takes.
However long it takes. Is that right?
That's correct.
Mr. Chairman, do you think all of the members heard what you just said?
I'm sure they did.
Well, in that case, Mr. Chairman, would you use the gavel and your influence as the chairman to help move this along and stop your colleagues from wasting all of our time?
Will the gentlelady yield? Will the gentlelady yield from California? Will the gentlelady yield?
And we will do our best to expedite.
Will the gentlelady yield?
The gentlelady only yields to the chairman so that he can repeat himself ad nauseum.
Does the gentleman from California wish to yield back her time, or does she wish to?
Can I have just a
gentlelady from California yields to the chairman. Are you convinced that your colleagues heard you, Mr. Chairman?
Am I convinced that my colleagues have heard me?
Yes.
I am.
Do you need any? How much more time do I have?
They may have heard me. They may not heed me.
Mm-hmm. Well, I think you can encourage them to move forward once they understand that no matter how long they obstruct, that you are going to proceed, you are going to move forward.
With you at my side, I will go forward. Yes, that is correct.
All right. Thank you, Mr. Chairman.
Thank you, Ms. Waters. Is there anyone else who wishes to be recognized on this amendment? The gentleman from Ohio, Mr. Jordan, is recognized.
Thank you, Mr. Chairman. Before yielding to my colleague, let me just say it's not always a bad idea to take a little more time. In fact, I know there are members, probably on both sides of the aisle, who wish that yesterday we had taken a little more time on the Defense Authorization Act, where there was a real concern about detainees, American citizens. So it's not always a bad idea to do that. And we want to get a remedy here. We want to get to a solution, but it's not always bad to, particularly when you're making the law that's going to apply to this great country, it's not always bad to take a little extra time. And with that, I'd yield the remainder of my time to the gentleman.
Would the gentleman yield to me for just a second to make the chairman aware of something?
Yield first to the gentleman from California.
I thank you. Mr. Chairman, I would note that there is a conference going on now, and I realize it's a Republican conference, but that conference is about how we come together to get out of here for Christmas, and that the members who are here on our side of the aisle are here because we think this is important, but I might strongly suggest that after this particular round, as soon as possible, we be allowed to have a short recess so we can participate in that conference and hopefully bring to a close the first session of Congress. I yield back. Thank you.
Will the gentleman yield for a moment?
No.
Thank you.
I would just put on the table the possibility that we might ask for a classified briefing from those at DHS and NSA with respect to the DNS SEC program and whether or not, in fact, there is a basis of concern that this particular remedy contained in this bill does demonstrable damage to that program to protect the Internet, upon which so much work has been done by DHS over the last 8 years.
Thank you. Yeah, again, I just want to briefly respond to the gentlelady from California, Ms. Waters, and to the chair as well. I don't sense that anybody here is being dilatory for the sake of being dilatory. I think there are real issues that have been raised. There's a real desire to hear from engineers and professionals. I think that there are real concerns about a bill, and there's hesitancy to support a bill from people that otherwise might support it. I think this bill can and should have a strong bipartisan majority for it, but all the questions that I've heard from my colleagues on both sides of the aisle that need to be answered have not been raised in a dilatory sense. They've been raised in a very sincere sense, and I hope that the chair appreciates that. And I'll yield back to my friend.
Will the gentleman yield?
Let me yield first to the gentleman from Utah. If I have time, I'll yield to him.
I appreciate those comments. I concur with the gentleman from California who suggests a classified briefing would also be in order. The reality of the calendar, Mr. Chairman, is that, and as the gentleman from California indicated, this problem has been going on for years. if we were to simply, as a body, take 7 legislative days to become more informed, because I'm not going to plead that perpetuation of ignorance is a good thing and we ought to move the bill forward anyway. I don't think that's a good strategy. I think it's a bad precedent. Certainly, 7 legislative days would be a reasonable time to get through some of these core questions. I may still ultimately vote no, but I might vote yes. But even if I were to vote no, I think it would be the smart, prudent thing to do. It is the right thing to do for this body. We cannot get this wrong, and there is nothing magic. There's nothing that's going to expire at the end of the year. There's nothing that's, magical has to happen before Christmas. Let's make sure we make the right move. Because even today, the manager's amendment, the very first amendment was an amendment to the amendment because we didn't get the definition of Internet service provider right. I think that was the one that was Mr. King's amendment. Domestic Internet site. We have to get this right. I want to get it right. And I think 7 legislative days, a classified briefing would be a prudent move, and I can't imagine an argument against that.
Will the gentleman yield? Thank you very much. It is the ordinary course of business to amend a manager's amendment. It's nothing unusual about that. As a matter of fact, it is the ordinary course of business, and usually, even with the manager's amendment, we could have scores of amendments.
Let me just reclaim the time. The gentleman from Utah.
Responding to that, what was agreed to was not the amendment. The agreement was we need to clean it up later. That was the agreement on the definition of domestic Internet site. It wasn't that we accepted the amendment. It was, all right, we don't know what the answer to that is, and we'll fix it later. That's the highlight of a major bill and a very basic definition. We haven't even got that part right.
Mr. Chairman.
Would the gentleman yield?
The gentleman from Ohio still has the time.
Yield to the gentleman from California.
I don't want to be derisive, but whenever we don't understand basic things that are in the bill, then what we're saying is let's pass the bill and then find out what's in it. Now, on both sides of the aisle, we don't ever want to hear that word said about anything we do again. So please, let's find out what's in this with fact before we move forward. Thank you.
Gentleman's time has expired.
Mr. Chairman.
The gentlewoman from Texas, Ms. Jackson, is recognized.
Thank you very much, Mr. Chairman. I've waited patiently for several points that I would like to make. First of all, let me join with, I think, the gentleman, Mr. Jordan, who indicated that it is appropriate that we have a thoughtful discussion, and I thank him for that. And to the gentleman from California, both of us sit on the Homeland Security Committee, maybe 1 or 2 others I'm looking, and I raised the point that you've raised, Mr. Lundgren, but I'd also raise the point, I'll use the layman's term, about the architect of the Internet is fast changing. And so my concern is with the legislation and not taking the time, whether or not the bill fits to the uniqueness of what we are regulating. And I am as willing to write legislation that interjects the Attorney General and courts as anyone else. As a lawyer, I pride in the judicial system. But the architect of what we're dealing with, the creativity of the Internet, may in fact be, if you will, diminished severely by the structure of this. On one hand, the security of the nation. On the other hand, being able to complement the architect of what we're regulating with how we have done so. And then, Mr. Chairman, if I might have a moment of personal privilege and just cite for my colleagues, because I do think that we should be respectful of each other. I'm reading a tweet that is going out from GOP Rep. King, bored by the dialogue of Representative Jackson Lee. I have no reason to think that anybody cares about my words, but I would offer to say that Mr. King owes the committee an apology, said that we're debating the Stop Online Piracy Act, and that he is killing time by surfing the Internet. I've never known Mr. King to have a multitask capacity, but if that is his ability, I do think it's inappropriate while we're talking about serious issues to have a member of the Judiciary Committee be so offensive. So I'm putting on the record he is not here.
Chairman, I demand that gentlewoman's words be taken down.
Well, I'm not taking them down, so you can break this hearing because I'm not. I would ask Mr.
Chairman, I demand the regular order.
I'd ask, excuse me, I'm in the middle of my dialogue and I will continue.
No, the gentlewoman will suspend.
I have a personal privilege at this point.
The gentleman from Wisconsin will state the words he wishes to be taken down.
I wish to have the words taken down where the gentlewoman said that Mr. King of Iowa was being offensive.
Let me ask the clerk or to the stenographer to read that part of the transcript if she is prepared to do so that included that word.
That's right.
Let me ask the stenographer, is she going to be able to find those words or? Okay. I agree. While she is checking, let me ask the gentlewoman from Texas, Ms. Jackson Lee, if she would consider whatever words might be discovered that deal with the word offensive might ask that those words be withdrawn from her statement.
Mr. Chairman, let me thank you for your courtesies. You have been enormously patient. Frankly, if my colleagues heard me, I asked that Mr. King give the committee an apology for reflecting badly on the committee as we are debating a very important topic.
Chairman, I demand the regular order.
Will the gentlewoman from Texas respond to my request? Would she be willing to ask that those words that deal with the word offensive be removed from her statement?
I am not aware of why Mr. Sensenbrenner is making this request, but I will not.
You will insist on those words?
And until the, if you allow me to speak, I believe that Mr. King, who is not here, should apologize to the committee.
Chairman, that is beside the point. We'll wait for the stenographer and give everyone a chance to think about it for a minute. There, if you could read the words, that would be great.
Okay, well, she makes a point of personal privilege and just cite from my colleagues because I do think that we should be respectful of each other. I'm reading a tweet that has gone out from GOP Representative King, bored by the dialogue of Representative Jackson Lee. I have no reason to think that anybody cares about my words, but I would offer to say that Mr. King owes the committee an apology. He said that we are debating the Stop Online Piracy Act and that he is killing time by surfing the internet. I've never known Mr. King to have a multitask capacity, but if that is his ability, I do think it's inappropriate while we are talking about serious issues to have a member of the Judiciary Committee be so offensive. So I'm...
Okay, I thank you. I bet you've never had to do that in a while, have you?
No.
You did a good job. Thank you. May I ask the gentlewoman from Texas, my colleague and friend, if she might consider just asking that the record not include the word offensive, and then we can move on. We won't, in doing so, we won't prejudice her one way or the other as far as her remarks go. And we can certainly discuss with the gentleman from Iowa, and I will at a later time, some of the suggestions that the gentlewoman has made.
Mr. Chairman, if I might inquire, if I am to be cooperative, then I would expect...
Mr. Chairman, I demand the regular order again.
The gentleman from Wisconsin knows the rules of the committee very well, and so may I repeat my question to the gentlewoman from Texas. Would she consider removing the word offensive from the record and then she and I can continue to discuss the subject, and I will continue to discuss the subject with the gentleman from Iowa as well.
Mr. Chairman, if I could probe you just a little bit more, because at this time I'm not inclined to do so. I'm trying to determine what response will I draw through this committee.
Let me say to the gentlewoman, because we need to move on and get an answer, that the word that was used might well be taken to have impugned the integrity of a member of this committee, and therefore I'm trying to avoid having to make an official ruling to that effect, and I'd appreciate it personally if the gentlewoman would consider just having that one word stricken from the record.
Yes, Mr. Chairman, is it possible for me to consult with a parliamentarian?
Of course.
And I would appreciate doing so, please.
Okay.
Is there one here available, or can we call the one from the House?
There's one standing behind me who will make his way down to your chair.
Is he posing to be objective, or he is totally inclined to be?
Now, wait a minute.
I only asked a simple question.
She is not questioning the parliamentarians.
Is he making his way down? Is it a gentleman or a lady?
The gentleman is making his way down.